Thank you all. I call our meeting to order. And Robert, if you would please call the roll, please.
Senator Berg. Senator Carroll.
Here.
Senator Deneen. Senator Neal. Senator Schickel.
Here.
Senator Stivers. Senator Storm.
Here.
Senator Wheeler.
Here.
Representative Banta. Representative Blanton.
Here.
Representative Bratcher.
Here.
Representative Bray.
Present.
Representative Burke. Representative Decker.
Present.
Representative Dietz. Representative Doan. Representative Flannery.
Here.
Representative Griffey. Representative Herron. Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox.
Here.
Representative Mosher. Representative Nemus.
Here.
Representative Petrie.
Here.
Representative Rawlings. Representative Sharp.
Present.
Representative Stevenson. Representative Wilson. Co-Chair Westerfield.
Here.
Co-Chair Elliott.
Before we jump in, obviously, I want to welcome Chief Justice Van Meter before I call him up here, and Chief Justice-elect Lambert for the State of the Court's address. I want to recognize our outgoing members and retiring members. Some of them longtime members of this committee, predating my service here for sure. Senator John Schickel, who's retiring, who is here. Thank you, John, for your service. Representative Kevin Bratcher, who's retiring and won his race to Metro Council earlier this week. Thank you, Kevin. And two other members who are moving up to the Senate. I'm still going to recognize you because you're not going to be House members anymore. Representative Keturah Herron, or Senator-elect Herron. And Senator-elect Rawlings. Glad to have you. Congratulations to all of you. Thank you all so much for your service. John and Kevin, in particular, as you're leaving the body, I'm thankful for both of you. Even when we disagreed, I'm thankful for your service, and I appreciate the time and dedication you've put into work for the people you represent on this committee and off of it. Thank you both very much. Senator Wheeler.
Mr. Chairman, I would like to take a point of personal privilege to note that this is I believe our first meeting since our colleague Senator Turner passed that served on this committee.
Yes, sir.
As many of you all know, Johnny and I were great friends, both professionally and legislatively. Our career paths. He was older than I was, but often overlapped. We did a lot of similar types of law practice, and I think something that can be said not only about his commitment to this committee and his legislative service was the fact that he was a brilliant lawyer in his practice and had represented thousands of people all over southeastern Kentucky. I think that it's worthy to note that our thoughts and prayers, I hope it will continue to be with his family during this very difficult time. He was a larger-than-life person. I think that's going to be missed by all. So thank you for this for being this recognition, Mr. Chairman.
You took the words out of my mouth, Senator, so thank you. And it's appropriate that you would be the one recognizing your colleague from Southeast Kentucky. We miss Johnny, and we're thankful for his service. And I encourage all those believers to keep his family in your prayers as they continue to grieve and heal from his passing, which is certainly untimely and unfortunate. Anybody else have any other remarks or guests that they want to recognize here today? Seeing none. Is there a motion to approve the minutes from the October 17th meeting? Got a motion. Is there a second? Got a second. All those in favor, please vote by saying aye. Aye. Those opposed? Minutes are approved. Thank you. Mr. Chief Justice, we're glad to have you this morning. Come on up. And Chief Justice-elect Lambert, you're welcome to come up if you'd like. No pressure. I do want to also recognize I didn't see her in the audience. I still don't see her, but I extended an invitation to Justice-elect Goodwine. I want to wish her congratulations joining the court in the new year. She didn't know about the meeting until I texted her and let her know after Election Day, so I'm sure her docket kept her from being here today. Welcome, Chief Justice Van Meter, for your State of the Courts address to the Interim Joint Committee on Judiciary. Your last one and my last one. I'm eager to hear what you've got to say. You have the floor, Chief.
Thank you, sir. I will say, though, when I saw Senator Westerfield being called down and a priest, didn't know if that was confession or absolution or what.
Could have gone either way.
Could have gone either way. So, Chairman Westerfield, Chairman Elliott, esteemed members of the Judiciary Committee, and distinguished guests, good morning. Today, I have the privilege of delivering my final State of the Judiciary address to this honorable committee. It comes at a time of great transition to our court system. In the coming years, the judicial branch will undergo significant changes with the goal of modernizing our court processes and improving access to justice for Kentucky citizens. Transitions in leadership, technology, and policy can bring challenges, but they also provide opportunities to strengthen our commitment to justice. With thoughtful planning and collaboration, we are ready to embrace this moment of transformation to ensure that Kentucky's courts continue to serve the people with integrity. As we continue to evolve, we welcome a new chapter in leadership for the judicial branch, and while she needs no introduction to this committee, I want to recognize Deputy Chief Justice Deborah Hembry-Lambert as our Chief Justice-elect. She will begin her 4-year term on January the 6th at 12 a.m. Chief Justice-elect Lambert is dedicated and hardworking member of our judiciary with over 17 years of experience on the bench, having served as a family court judge, a Court of Appeals judge, and a Supreme Court justice. She is well respected for her leadership as Deputy Chief Justice and as chair of the Kentucky Judicial Commission on Mental Health. Her career is a testament to her commitment to justice. Chief Justice-elect Lambert, with her wealth of experience and devotion to justice and the people of the Commonwealth, will lead this branch with the same integrity and commitment that has defined her career. Kentucky's court system is in capable hands as we move forward in this period of change. We also will welcome a new director of the Administrative Office of the Courts. Chief Justice-elect Lambert recently chose a new director to lead the operational arm of the judicial branch. Zach Ramsey will begin his tenure as AOC director in early December of this year. Mr. Ramsey brings to the branch a wealth of experience and knowledge from private software sector and from state government. He will be a valuable addition to the Kentucky Court of Justice. The role of the AOC director is integral to the judicial system's daily operations. The director oversees the branch's budget, nearly 3,300 employees throughout the state who execute the judicial branch programs and support services. The AOC provides services to Kentucky's 412 elected justices, judges, and circuit court clerks, and I'm confident that Chief Justice Lambert has chosen the right person to take on this important role. Incoming leadership will be focused on technological advancements that are already underway to help our judiciary adopt and thrive in the digital age. The most significant advancement is the implementation of a new trial court case management system, or CMS. The project is the cornerstone of our efforts to transform Kentucky's judiciary into a fully digital world connected with all its partners by technology. It also represents a pivotal milestone in our move towards a fully electronic record. In 2022, the legislature gave the judicial branch a once-in-a-generation opportunity by allocating $38 million from the American Rescue Plan Act to update its 2 decades-old in-house CMS. Recognizing the challenges of attracting, retaining, and compensating technical talent sufficient to maintain a legacy system, we pursued a vendor-provided solution. After a competitive process, we selected Tyler Technologies as the vendor for our new CMS. This evaluation process included judges, circuit court clerks, and experts from AOC. Tyler is the recognized leader in public sector judicial software. It has a proven track record servicing 21 other statewide court systems. In fact, our neighboring states, Indiana, Illinois, Ohio, West Virginia, and Tennessee all use Tyler software on statewide or on a county-by-county basis. Tyler also services North Carolina statewide. North Carolina, like Kentucky, has a unified court system and faces similar challenges in providing court services that effectively meet the needs of both rural and urban communities. Tyler's experience in addressing these complexities makes it well equipped to support Kentucky's courts. The new case management system will run on a secure, cloud-based platform offering stronger protection for sensitive data and greater accessibility to software upgrades. The new CMS also heralds Kentucky's next evolution of electronic filing. It all began in 2013 when we accepted the first e-filing through a pilot project in Franklin County. Fast forward to now, and electronic filing is mandatory for attorneys and judges in nearly all district, circuit, family court case types. With the adoption of Tyler's electronic filing system, Kentucky will be poised to begin its transition to an all-electronic record. We will go live with the new electronic filing system in select counties next fall, with statewide implementation to begin thereafter. The CMS will go live in select counties in the late summer of 2026, with statewide implementation beginning 2027. Through the transition to a new CMS and electronic filing system, although it's a significant leap forward for Kentucky, we know it will come with challenges. Such a large organizational change needs careful planning and coordination at every level. The American Rescue Plan money has been wisely used for this transformation and will be applied to finance these systems for several years to come. However, as with all cloud-based software services, these enhancements will require an ongoing financial commitment in the years ahead to support and sustain them. Nonetheless, our selection of Tyler's cloud-based software service is consistent with our commitment to being fiscally responsible. The cost would have been the same whether we chose an on-premise or cloud-based service. By selecting the cloud, we're investing in a more secure, stable, scalable, and future-proof solution that will serve Kentucky for many years to come. The resources required to maintain, archive, or destroy a paper record are substantial. New systems will allow us to begin the transition to an all-electronic record, decreasing the strain on our resources, increasing access to courts statewide, and making implementation of new laws like expanded automatic expungement possible in prospective cases. I want to address briefly juror compensation. Ensuring our court system is efficient and modern also means prioritizing fair compensation for jurors. Although juror compensation is not funded through the judicial branch, it is essential to assure jury pools accurately reflect our communities. We applaud the General Assembly's request for a juror compensation study to be presented later this year. I would note a significant finding in the study is the dramatic loss of buying power in Kentucky's juror compensation. Juror compensation has remained at $12.50 per day for nearly half a century. Today, to match the purchasing power of $12.50 in 1978, juror compensation would need to be increased to $70. This gap highlights the urgent need for reform. Also want to address probate filings. Just as we seek to improve juror compensation, we must also consider reform of our probate laws to better meet the needs of our citizens and practitioners. Current statutes governing the disposition of property and the appointment of personal representatives are outdated and do not reflect modern practices. While the judiciary aims to update procedural requirements in probate proceedings, these efforts require collaboration with the legislature, the bar, and practitioners. Together, we can create a more efficient and reasonable probate framework. In the interim, we are implementing several immediate measures to assist courts, practitioners, and self-represented litigants. A work group is reviewing the AOC's legal forms to provide improved efficiency of resolving probate matters under existing law. We are also updating court processes for circuit court clerks, e-filing instructions for practitioners, and a legal self-help guide for self-represented litigants. These actions demonstrate our commitment to enhancing efficiency and accessibility in our courts while exploring long-term options for modernizing probate law and practice. As to statewide programs, let me share updates on key programs that support children and families and address mental health to ensure Kentucky continues to thrive well into the future. These programs are a reflection of your initiatives and support, and we continue to be thankful for your innovative approaches to serving our communities. The Citizens Foster Care Review Board provides findings and recommendations to judges for nearly every child reviewed. We have 173 boards across all 120 counties. In 2023, 725 volunteers conducted over 20,000 reviews for nearly 12,000 children in foster care. As a part of 2018's House Bill 1, the boards now host public forums. These public forums let the community voice concerns about foster care and identify barriers to child safety and well-being. Additionally, court-designated workers by statute are required to process all complaints filed against children under the age of 18. In fiscal year 2024, court-designated workers processed almost 17,000 juvenile complaints, which is a slight decrease from those processed in the prior year. Moving on to our mental health initiatives, funding was appropriated this biennium to expand mental health courts to 10 additional sites. These new locations cover the counties of Bourbon, Christian, Clark, Floyd, Franklin, Harlan, Hopkins, McCracken, Perry, Pulaski, Scott, and Woodford. That brings the total number of AOC-supported mental health courts to 15. The new sites are expected to begin rendering services to target populations in early 2025. To support these mental health courts, behavioral health liaisons will provide critical guidance and navigation services for justice-involved individuals facing mental health, substance use, and developmental challenges. The liaisons serve as key connections between the court system and community partners to improve access to necessary treatment and support services. Additionally, the implementation of the Behavioral Health Conditional Dismissal Program provided under 2022 Senate Bill 90 is underway in 11 counties and will expand to 6 more. We remain focused on identifying further opportunities to advance the General Assembly's Senate Bill 90 initiatives. While a detailed Senate Bill 90 presentation will follow my address, I want to briefly highlight a related effort. In Johnson and Warren counties, our mental health court initiatives have been integrated into Senate Bill 90 efforts. A grant from the Bureau of Justice Assistance provides pretrial services at specialty courts in identifying justice-involved individuals at the earliest possible stage and guiding them to appropriate programs for accountability and treatment. This could include mental health courts or behavioral health conditional dismissal program, depending on the individual's needs. This approach aligns with the sequential intercept model, which maps the criminal justice system across 5 intercept points from initial contact with law enforcement through reentry into society. By identifying and intervening with justice-involved individuals early on, we are advancing one of Senate Bill 90's primary goals of addressing behavioral health needs at critical points in the justice process. The Supreme Court remains committed to supporting the Kentucky Judicial Commission on Mental Health. The justices have added 9 new members to drive systemic change for justice-involved individuals with mental health challenges, substance use disorders, and developmental disabilities. And I'll interject here that Justice Lambert had been in charge of this, but with her new role, she has appointed new Chief Deputy-elect Bob Conley to head up this effort. So this year's House Bill 385, known as Seth's Law, has set a transformative precedent by reducing outpatient competency evaluation times from 12 months to just 3 to 5 weeks, significantly improving competency and guardianship practices statewide. We thank you for supporting this impactful legislation and are pleased to announce additional legislative recommendations from the Commission for the upcoming sessions. These include amending 2 laws, KRS 199.471 and KRS 625.090, to prevent adoption and termination decisions based solely on a parent's disability. The Commission requests these laws to mandate reasonable accommodations tailored to individual needs. Earlier this year, the Commission partnered with AOC to champion recovery-oriented systems of care summits, reaching over 1,050 court professionals and partners. Committed to statewide progress, the Commission is advancing change through 10 work groups with over 400 partners participating, and has introduced the nation's first system mapping model for child welfare, criminal justice, and juvenile justice at the local level. I want to extend my appreciation to the General Assembly for its recent budget allocation for the maintenance of county court facilities, which includes a $53.5 million maintenance pool. This funding will support a variety of projects associated with HVAC, roofs, and electrical systems statewide. Additionally, it will fund significant county court projects such as the renovation of Jefferson County's jury assembly room, the relocation of Jefferson County's data center, the renovation of Canton County's family court area, and essential masonry repairs in Warren County. These improvements will enhance county court facilities across the state and then ensure they continue to meet the demands of their local communities. With respect to our operations, and while we have made strides in securing raises and funding for specific judiciary projects and initiatives, operational costs are increasingly challenging. The judicial branch has operated at a deficit since 2010, relying on vacancy credits and agency revenue to bridge the gap. However, these savings have diminished in recent years, compounded by inflation impacting the cost of essential goods and services. We anticipate, and I'll interject here, that I appeared before the Interim Committee on Appropriations and Revenues to detail those needs, so I won't go into those here. We anticipate submitting a budget request in 2026 to address these challenges. Until then, with 90% of our operational budget dedicated to personnel expenses, we have implemented cost-saving measures to avoid any reduction in court services. This includes requiring vacant positions as of November 1st to remain unfilled for 90 days, submitting out-of-state travel paid for by the general fund, encouraging the use of Teams or Zooms in lieu of non-essential in-state travel, and reverting operating budget to last year's levels. These initiatives are a part of our commitment to fiscal responsibility in the short term, ensuring that Kentucky's judiciary remains efficient and sustainable despite present budget constraints. So, in conclusion and moving ahead, it's important to remember that all these efforts, from new leadership to improved technology, are about building and maintaining public trust in our courts. After all, without trust, we cannot effectively resolve disputes and deliver equal justice for all. With continued support of the General Assembly, particularly this committee, the bar, and our many justice partners, we will keep strengthening our courts and upholding the rule of law. Together, we're ensuring Kentucky's judicial system is ready for whatever the future brings. Thank you for your dedication to these efforts and for your partnerships. So as I prepare to retire from the bench, I leave with immense gratitude for colleagues, partners, and public servants who have made this journey so rewarding. I'm confident that with your continued support, the future of Kentucky's courts is bright. Over the last 31 years, I've gotten to know a number of you. I remember Representative Elliott when he was just, a wee attorney over in Bull County, and, got to know him. Representative Dietz, I've known her for a while. Representative Nemes, I remember him when he was in a prior role. And I just, I've really enjoyed working with y'all. Representative Dunn, congratulations to you. So I could go and recognize every one of y'all, but I just have enjoyed my time working with y'all and getting to know you better, and I'm sure I'll see you around campus. So with that, I'm happy to take any questions you have.
Thank you, Chief. Representative Nemes.
Thank you, Mr. Chairman. I want to first say thank you to the Chief Justice for his service, many years on the Court of Justice, and very good service as the Chief Justice over the last 2 years. 2 years. In 2 years from now, we'll have the 50th anniversary of our Court of Justice, when our people went to the polls and they put together a new judicial article, passed a judicial article, and it's one of the gems of our whole system. And so can't wait to celebrate that.
Didn't somebody write a book about that?
Somebody did at the 30-year anniversary.
Okay.
That's right.
Okay.
So 20 years have passed since then. a lot of good stuff. And you know, Kentucky's great Chief Justice Joseph Lambert was the Chief Justice at the time, and I remember our budgets were outrageously good. I mean, they were wonderful. Our judges were, you know, top 15 paid in the country. Now I think we're the second worst. We had about 10 years where the judges didn't get any raises. This General Assembly has changed that, and we've given significant raises to judges, circuit clerks, and most importantly, deputy clerks and pretrial officers and frontline workers. We're very proud of that. And I'm glad that you've uncovered some of the problems that we've had in budgeting in the last 14 years. I was in charge of the judicial budget for 6 years. Representative Flannery is now. I have never heard that there was a fundamental problem in the operations budget since 2010. That was the first budget, I think, of the previous Chief Justice. I hadn't heard that. I was very proud that every time that you guys asked for something, we gave it to you. And we started to implement judicial raises after about 8 years of no judicial raises. And so this past year, you guys asked for a dollar amount, and we gave it to you. In April, you sent an email out to all the Court of Justice statewide praising that budget. And the budget will provide for the important work we do for the next 2 fiscal years. With this budget, we will be able to maintain operations at current levels while meeting critical needs. Gave 3% raise, new Court of Appeals building. We're very proud of that. We want our judiciary to be the best in the country again, and we want to do those types of things. We want to increase the pay for those who are working really hard. I want to just put on the record that we met that request that the judiciary had made, and we've been doing that for years. I'm glad that you, as the new Chief Justice, have uncovered a decade of, I guess, ineptness in the. I don't know what else to say. How you could say that our operations weren't being funded. We didn't know that. We've always met the budgetary request. I'm sure with Chairman Petrie and Chairman McDaniel and Mr. Flannery, we'll do that in 2026 and right the ship again. I'm glad that Debbie Lambert will be our next Chief Justice. Maybe it takes a Lambert to get it right. I don't know, but we're very. We look forward to making sure that we adequately fund the judiciary. But I wanted to set it straight for every judge and every clerk in the Commonwealth of Kentucky that what was asked for was given, and so that just had to be said. And so, but that's not on you, Chief Justice. You've only been there for 1 term, 2 years, and working with you has been a delight. I think you've brought a fresh way of looking at things, and I look forward to the years to come with Chief Justice Debbie Lambert. Thank you, Mr. Chairman.
Senator Schickel.
Thank you, Mr. Chairman. Thank you for that report, Chief. And you and I are both retiring, and this is my last judiciary meeting. I think next to the Senate President, I'm the senior member of this committee. And so I have a couple of things I want to say, too, just general things. Even before I had this job, I've always had jobs where I was very closely associated with the courts. And being a member of the party of personal responsibility, or at least it used to be, I am concerned, and I know this is the minority opinion, but I am concerned, and I know of others that are very concerned about our Court of Justice turning into a social service agency. The name of the agency, Court of Justice, I think says it all and says what ought to be the primary focus of our courts. On the criminal side, determining innocence and guilt and punishment, and on the civil side, deciding civil disputes. And it troubles me that the focus of the judiciary is so much on social services. Not that social services don't have a role, but I don't think it's the role of the judiciary. So I just wanted to share that with you. I know I've said it before, but I just wanted to say it again here at my last meeting because it concerns me, and I know it concerns others.
Members, any other questions? Chairman Elliott.
Thank you, Mr. Chairman, and I wanted to just take a moment to thank Chief Justice Van Meter for his service to the state. And, you've been in Boyle County a lot over the years, and I think I was with you about almost every time you were there over the years. So you mean a lot to the people there and to me, and I thank you for your friendship. I thank you for your service. It's been historic, as you've served on all 4 levels of the courts. And so I just want to thank you. I want to wish you well in your retirement, and thank you for being a friend to me. I've really appreciated it.
I'll wrap up. Actually, I have a couple of questions. One, I don't think I heard you mention it. Can you give an update on Graves County's facility? Or anybody on the team?
I might need to pull somebody up to help me.
That's fine.
Danny Rhodes,
Yeah.
our Director of all things facilities. We'll let him give the update.
Good to see you, Danny.
Good afternoon.
Just tell us where it is or what the status of things are. I asked last year. I've asked in the interim a couple of times, but I'm curious where things stand today.
Yeah, so we are currently still in the process of site selection.
Oh, wow.
There is 3 properties that have been identified that the PDB, Project Development Board, is vetting the options of what would be the best location for that. 2 of which are within a block to 2 blocks of the previous existing courthouse. The third is about a mile and a quarter away from the downtown area. But based on some condemnation proceedings that have taken place by the city, that process has been delayed, as far as selecting the right property that the PDB wishes to make a decision on. So,
all right. Thank you for that. I appreciate you hopping up there, spur of the moment.
No problem.
Changing gears, not about facilities, Chief, and it's not a question as much as it's a request for you and Chief-elect Lambert for the court to make sure you do. As you work on your new case management system, you've got a vendor. I've had this conversation with your director, with Director Comstock when she was there, and I haven't had this opportunity to talk with Interim Director McGinnis about it, but I've had folks from AOC, from Prosecutors Advisory Council, or rather from the AG's office, and the Justice Cabinet. I implore you, make sure your systems talk, and make sure that victim notification is part of the system. You all have pledged through your letter, which I appreciate, following an interim meeting a few months ago, you all have pledged whatever data is necessary for the other agencies that are going to be tasked with doing this. I just want to make sure that that still happens so that your system talks to the prosecutor system, and they're in the process of doing some sort of case management. They've been talking about that since I was a prosecutor, and it still hasn't come to fruition yet. I hope it does. I just want to make sure that those 2 systems and justices with DOC in there talk, so that victim notification is a first order priority of the system. You all send alerts to your litigants every day by text, your criminal defendants all the time. It works beautifully. Victims should be able to benefit from that same thing. So I humbly beseech you to see that that is done. Any other questions or comments? Chief, it's been a pleasure.
Thank you.
Thank you so much for your service. Senator?
Thank you.
Brian. There you are. Come on up. I want to welcome our colleague, Senator Cassie Chambers Armstrong from Senate District 19. And do you have your guest with you? There she is.
She's making her way up.
Miss Aubrey. Aubrey, how do you say your last name?
Gerard.
Gerard. All right. That is a spelling I am not familiar with. Sorry about that.
No, that is fine. I'm recently married, so I've decided to confuse everybody. So.
Got it. Well, Mr. Gerard, it's a pleasure to have you. Senator, it's good to have you. You have the floor.
Thank you, Mr. Chairman, and thank you for letting me talk about this important issue. Although I am the senator for the 19th District, today I'm mainly going to be speaking to you all as a researcher who researches court systems. I started my legal career as a legal aid attorney providing free legal representation to survivors of domestic violence in rural Kentucky. And what I learned from that experience, I was based at the Louisville Legal Aid Society. I was the only free family law attorney for a 14-county service area. And the challenges that I saw in my role in rural courts felt different than many of the challenges that my colleagues were seeing in the urban courts in Louisville. And I realized that some of those concerns don't necessarily get elevated in the same way when we're talking about our court system. And that set me off on this path to begin to try to quantify that, to begin to try to find evidence of what are the differences in how our urban courts and our rural courts work, where are we under-resourcing our different types of systems, and ultimately, at the end of the day, what can we do to support survivors of domestic violence and make sure that they can navigate the court system? And all these laws we pass to support survivors mean something because people can utilize the courts for relief. So I'm here today not to advocate for any policies. I have no draft legislation. I have no ideas that I am peddling. I'm just here to provide you with numbers and data and hopefully begin a conversation about some of the places that we could improve to support survivors of violence in our communities. I want to start just by reminding, I know many of the lawyers know this, but reminding folks about what the definition of domestic violence is in Kentucky. States vary along two different dimensions when we're classifying domestic violence for protective order processes. It is first, what type of conduct counts as domestic violence, and you can see Kentucky, in Kentucky that is physical violence or a threat of physical violence. There are other states that include malicious property destruction, coercive control, representative deeds, or other types of acts that many organizations will put on that wheel of domestic violence. But in Kentucky, legally, we're talking about physical injuries or threat of physical injuries. The other thing we're looking at is what is the relationship between the parties that entitles someone to seek relief. So for a domestic violence order in Kentucky, you have to have a familial relationship. And you can see up here the definition of a familial relationship. We're looking at folks who are spouses, folks who have shared a home, folks who have a child in common. I didn't put up here the definition of a dating relationship, although that's another way folks can qualify under the statute. So we're looking for a prohibited type of conduct that counts as domestic violence, and we're looking at a qualifying relationship, folks who satisfy that family relationship or that dating relationship that allows them to go to court and get a protective order. So I'm going to talk about two studies I've done today very briefly. And study one, I'm very grateful to Zero V. I know folks on this committee know them well, and I know Meg is here in the back and happy to answer any questions about the amazing work that they do. This study was really possible because of Zero V. Zero V has advocates in every Kentucky court system that help folks navigate the protective order process. And these advocates agreed, out of the goodness of their heart, to help me collect data about what was going on. And so for one day last summer across, we ended up getting over 100 courtrooms. These advocates coded data and entered a survey about what was going on. I then took that and sort of took the survey, did some data analysis, and arrived at some of these numbers that I will share with you now. First, just a picture of what we're talking about. This is 101 courtrooms across 76 counties. If you're wondering why there are more courtrooms than counties, a lot of counties will have two divisions and or more divisions, and each one of those divisions has a separate judge and counted as a separate courtroom. 23 urban courtrooms, 77 rural courtrooms. You might be wondering, what's an urban courtroom and what's a rural courtroom? The population cutoff is 65,000. That's the top 15, about 10% of Kentucky counties, qualified as urban counties. That's sort of matching that definition to other literature. And the rest we qualified as rural courtrooms. We were looking at about 1,150 cases on the docket. And just so you know, the number of cases on your typical protective order docket, it ranged from 1 to 58. So a judge having their domestic violence court on a given day is going to have somewhere between 1 to 58 cases with an average of 11 and a half. And so I'm going to show you some numbers on some different things I looked at that I found interesting in this data. This first one is about attorney access. So when survivors are going through our court system, how many of those folks have attorneys? And we can see that less than 1 in 4 petitioners and a little bit less, about the same number of respondents, are going to have access to an attorney. And what I found interesting in this, you can see the stars next to urban and rural, and you can see that survivors navigating the process in urban counties were statistically significantly more likely to have access to an attorney than were those survivors in rural counties. And so you can see there's almost a 10 percentage point difference in the likelihood that folks were going to have attorney access. The next thing I looked at was this idea of information provision prior to court. And so one practice, I got all the ideas for things to look at from our great Zero V advocates. And one of the things they said is, hey, in some courtrooms, judges or the court system will actually give us information about who's going to be in court that day. They'll give us the docket sheet. And when that person goes to file for a protective order, they'll actually give them information about us and about our services. And we feel like petitioners are getting good information about the resources that are available to them, and we're getting good information about those petitioners. And so I decided to look to see if it was different on an urban or rural dimension. And what you can see is that about half of petitioners in urban courtrooms are getting that information about those advocacy services available through Zero V, whereas only about 22% in rural areas are getting that. And you see similar numbers when we flip it around and we look at advocates who are getting information about petitioners. Typically, what folks do with that, if they have a docket sheet or information about them in advance, they might try to contact them. They might say, hey, let me explain to you how the court system works. Is there anything I can do to support you? Are there other resources that you might need connected to? The next thing I looked at was docket structures, and I call this who's in, who's out, and who's online. So one thing that I noticed as a legal aid attorney is that in some counties they have what I call open dockets. So it's a general civil docket with all types of cases. You're going to have a probate case. You're going to maybe have some criminal cases. You're going to have everyone who has court that day or that week in the courtroom. And there have been a lot of studies that say that this makes petitioners less likely to move forward with their cases because they might not want to testify about their violence, their experience of violence with a whole bunch of strangers in the courtroom. They feel better whenever the courtroom is limited in some way so that it's maybe just the parties and the judge, or maybe just the other folks who have a domestic violence order case on that day. The more folks in the courtroom, sort of the more nervous petitioners tend to get and the less likely they are to move forward with their protective order. And so here we saw big differences. In the urban courtrooms, about half of those were closed just to the parties and the judge, whereas in rural courtrooms, only about 16% of those were. Most of those were open dockets, where it was general civil dockets. Maybe the domestic violence cases were called at the foot or at the head of the docket, but they weren't limiting access to the courtroom in any way. Next thing I looked at was virtual court availability. We know that every court now, after COVID, has access to virtual technology. The question is, can petitioners or respondents opt in easily to utilizing it? Is it something that it's on, sort of that motion that you send out that just says, if you would prefer to attend your hearing virtually, you can? The reason that this is important, one, we know that things like childcare, things like work can often make it difficult for folks to get to court, and it gives people flexibility. We also know that sometimes in domestic violence cases, people don't necessarily feel safe going to court, and a virtual court option can let them have some separation from that person that they are afraid of while still going through the protective order process. I will note that there have been some pilot studies of virtual court where they've asked people, did you feel more comfortable? And generally speaking, petitioners do feel safer whenever they have the option of opting into virtual court. And so you can see in about half of our urban counties, that was a choice that petitioners could utilize, whereas in our rural counties, it was about 14%. I will say every county told me that if you file a motion and you go through a process with the judge, we'll let you use virtual court. But that can be a lot to ask for largely pro se parties to go through an entire motion process to be able to utilize this technology. The last thing I looked at was what types of courts are people accessing. I'm really proud of Kentucky's access to family courts and the way that we have expanded access over the years. You can see that 100% of our urban courtrooms now have access to a family court judge who will hear those protective order cases. The idea being it's a judge who specializes in these issues, who sees these issues more frequently. These issues aren't competing with other demands on the judge's docket. Whereas in our rural courtrooms, it's less than half of those that have access to family court. And I do want to say, when I'm talking about, open dockets, closed dockets, virtual court access, none of these differences in no way imply that I'm not in any way trying to disparage our rural court systems. I know that the judges, the clerks, everyone is working really hard. My concern is that sometimes we don't evenly distribute the resources, and that perhaps we need to be providing more resources to some of these rural courts to make sure that they can serve survivors in the same way that urban courtrooms can. The last thing I want to talk about is the use of judicial discretion. So we know under Kentucky state law that judges are allowed to excuse a petitioner from coming to court until a respondent is served. The reason that this is really important is service is one of the biggest challenges in protective order cases. In my research in this set of data, 1 out of every 4 cases was passed over because there was no service. And we know there's a lot of other previous research that says we're dismissing a lot of protective orders just because we can't get people served. It's a big challenge to get that in-person service over folks. And we know that a lot of times petitioners will abandon their protective order case because they'll go back to court 1 time, 2 times, 3 times. They'll find childcare, they'll miss work, and finally they'll say, I just don't believe you're ever going to serve him, and I can't risk my job anymore, and I can't not make money anymore. Judges have the discretion to say, don't worry about coming back. We'll let you know when this person is served. We'll send you notice. Or instead to say, keep coming back every 2 weeks for that motion hour until we get service. We found that 81% of our urban judges would excuse a petitioner's attendance until they got service over a respondent, whereas a little less than half of our rural judges did that. I wonder if this is an education issue of just making sure that judges understand that they have that authority under Kentucky law. And finally, this was one where we didn't see a difference in urban or rural dimensions, but I think it's worth noting. I looked at the percentage of judges entering ancillary orders. And what I mean by ancillary orders are Kentucky law gives judges broad discretion in a protective order case to grant all types of relief. You can order a party not to engage in further acts of violence. You can deal with child support. You can deal with child custody. The statute actually says you can take any other measure you think is necessary to stop the violence. The only thing you can't do is require the petitioner to take affirmative steps. You can't require the person seeking protection to do anything. And so I look to see in cases where there are children, where child support or child custody might be implicated, how often are judges actually entering orders on that? How often are they addressing those issues? There's a lot of research that says when you address child custody and child support, it can actually decrease future acts of violence because you're giving that person the financial resources they need to support their child. You're also establishing a custody order so that the parties aren't likely to get into altercations over how they're time sharing. There's already an order in place that makes sure that that's happening in a safe way. So you can see only about 1 out of 3 cases where those issues were implicated were judges entering orders. So just a couple of key takeaways. Low levels of service in both urban and rural areas. Low levels of representation for both our petitioners and our respondents, regardless of where they were. Low entering of ancillary orders for child support, child custody. And we did see some differences based on place. We did see less representation in rural areas, less access to information about supportive services in rural areas, and some key differences in what those dockets look like and how those dockets operate across the state. And I promise this part will be very close because I know you all want to hear from Aubrey, who is on the front lines doing this work in our court systems every day and really has the perspective that needs to be elevated here. But the second study, and this is hot off the presses, these are preliminary results. You all are the first folks to hear them, and data collection is ongoing, so these numbers might change. But for this one, I had my wonderful research assistant, Andy Dahmer, who did a great job, look at about 1,000 Kentucky court cases and code these dockets for different dimensions. So to actually go and look at our court system and see how these cases were being processed. And a couple of things that I was looking at here, in terms of the average number of days from filing until a final order, we can see it's taking about 37 days across the state, which I'll be honest was faster than I expected, for folks to be able to get a final order. In our urban areas, it was 39 days. In our rural areas, it was 23 days. It turns out that lawyers add time to a case and family court adds time to a case. So those cases take longer. And so a lot of this difference, I think, is being driven by more lawyers requesting more hearings in those urban areas, and also family court judges perhaps having a little more time and capacity to be able to set some of these cases for hearings as opposed to ruling during motion hour. It takes an average of, someone has to go to court 2.6 times to get a protective order, 3.31 times in an urban area and 1.6 times in a rural area. A number that really surprised me was that we only saw petitioners being represented by legal aid in 3% of cases. That was across the board. That's really, in addition to the nest, the only resources folks have to access attorneys if they can't afford one. One thing I did think was interesting that varied by rural and urban dimensions is the average travel time to get to a legal aid office. It was 36 minutes across the state, but you can see a big difference was for urban folks, those resources were about 17 minutes from their house. In rural cases, for our rural petitioners, they had to travel almost an hour to get to a legal aid office. And you can think about all the ways that that creates a barrier to folks even initiating the protective order process when you're told you have to drive 51 minutes to meet with an attorney to help you begin to navigate this process. One thing that I'm still figuring out what the data says is that petitioners requested to dismiss about 10% of cases, and about 10% of them, a petitioner had filed a case and then went to the judge and said, actually, I don't want to go forward with this case. And we don't know if that's because they felt afraid. We don't know if that's because they had maybe a divorce or custody case going on. Haven't gotten that far in the data yet. But I do know that it's more likely to happen in rural areas where a petitioner goes to court and says, actually, I don't want to move forward with my case anymore. And also in rural areas, we're more likely to have those protective order cases dismissed at initial review. So the way the process works, someone files a petition, a judge looks at that petition and basically says, is this worth putting an emergency protective order in place, trying to get someone served, bring them into court for a hearing? And in our rural areas, judges were more likely at that initial filing to say, I don't think this meets the threshold, and so I'm not going to try to serve the respondent. I'm just going to deny this at initial review. And finally, about 25% of our protective order cases resulted in an actual protective order being put in place. So a lot of these are similar. Service of process is going to continue to be a challenge. Making sure folks have even access to resources is going to be a challenge. Making sure folks don't have to travel long distances to get to those resources is going to be a challenge. And I think that when I look at this data, what I see is that the structures we put in place in our courts impact our outcomes. They impact how people navigate these systems. And so I'll be happy to answer any questions that anyone might have. I do, if no one has anything pressing, I would like you all to be able to hear from Aubrey, who works at the Nest and is sort of on the front lines of this. But I'd be happy to answer questions in between.
I have one question from Representative Doan. There he is.
Yeah, they're not too pressing. It's probably more than one question, but just some information on how you gathered this data. Were these self-reported surveys as opposed to you going in and checking the AOC CourtNet data?
Thank you for the question. It's a great question. For the second one, it was the AOC CourtNet data. And so my wonderful research assistant literally went through every case in a rural court for 2022 and 2023. We actually just figured out how many cases there were and manually looked at every single case. And then we did a random sampling to case match in the urban areas. So actually looking at the dockets, the next stage is to actually get the orders, to go to the courts and ask for the orders. And then for the first one, it was our victims advocates sitting in court with this survey and reporting on every case that the judge called up that day.
Yeah. That's helpful. I know that I do a lot of these cases. I probably did 3 of them in the last month or so. And oftentimes my name will never appear in the AOC, but I was a part of the case. You know, I did it most of the way through. Did you distinguish in the data between domestic violence and then stalking cases? I've had crazy cases where like a landlord failed to properly serve a tenant and the tenant files for stalking and we end up in one of these cases and there's no familiar relationship at all.
Yeah, that's a great question also. So I did a lot of those denied at initial review ones. are because a judge looked at it and said that familial relationship isn't there, or you're not alleging any sort of physical violence, you're not alleging prohibited conduct under the statute. And so you can often see those noted, and where it was noted why a judge denied it. A lot of courts regularly do that in the docket line: denied, no familial relationship, denied, no qualifying conduct. I noted it in the notes. And like I said, that data processing is still at the pretty early stages. And so I think you're right. There might be some interesting things to look at along why judges are initially denying those orders.
Well, and it's not even there was a protective order put in place. There was no familial relationship. It's just that when you're looking at there's two distinctions. There's domestic violence cases and stalking, and they're all categorized in the same area. And so just making sure we're going through that data, because I think it's really limited on CourtNet. And then just a comment in this area while we're on the topic. I was in court the other day. I'll sit through the entire docket and watch all these just because it is an area we need a lot of work in. And there was an instance where the wife, or the mother, I should say, was the domestic abuser, abused father while he was holding their infant child. And it was clear from the hearing and from all the testimony, both parties represented that the father was the father of that child, but paternity hadn't been established, and that an act of domestic violence did occur and did involve that child. And that child was sent home that day with a domestic abuser mother because paternity hadn't been established. And our judges don't have the ability in those district court cases, they are quasi-district circuit court cases, to enter a paternity order or to order that, even though the parties had agreed that was the father. And so I've got a bill that I've drafted to address that issue, and I'd hope that you'd help me support that over in the Senate and make sure we get that through.
Yeah, I look forward to hearing about it. I think it sounds like you have a lot of examples of how the under-resourced system can really impact folks' lives.
Thank you.
Senator Wheeler.
Thank you, Mr. Chairman, and thank you, Senator Armstrong. I guess one question I have, and I think these are definitely a necessary protection tool, but did any of your research indicate how often, maybe in certain circumstances, these are used in a fraudulent way? And I'll tell you an example I had in my practice. It was an out of wedlock child. They were in a custody dispute. Paternity was established, but the father was a very avid sportsman, and amazingly enough, every hunting season came around, she'd go file for a DVO. It was in a circuit, a 3-county circuit, and so there was only a court docket every third week. And so they would go get all these guns, and, for the hunting season, by the time it got to the hearing, she would drop it. And it would get dismissed, but obviously the effect that I think she intended it to have was that he would get knocked out of hunting season every time with one of these things pending, which we finally managed to get that because his mother, who she continued to communicate with, basically she told him she'd done it to do that and caught him on tape. So it stopped after that. But do you know how often these things do end up in if there's any determination that there is any fraud in this process?
That is not something that I looked at. I do know that I've heard people expressing concerns that folks are using them because it can take a really long time through family court to address child custody or child support. My data doesn't really suggest that that's what's happening, only because we're only seeing a third of the cases where their kids have any orders related to the kids entered. Largely what judges are doing is just saying, I'm going to enter an order that says, I'm prohibiting future acts of violence, I'm prohibiting any unlawful contact. The next thing I'm going to do is actually look at those orders and code what judges are doing in every single case. And hopefully that will give us a little bit more information about what judges are actually doing and how they're ordering relief.
I mean, I think this is a great shield, but occasionally it is used as a sword, and I think we need to make sure that doesn't happen.
Representative, go ahead. Burke. Representative Burke.
Thank you, Chairman. I feel it is incredibly important to respond to the previous comment just by saying that In Kentucky, nearly half of women are victims of domestic violence and a third of men. So to say that we're worried about what I would say are very rare instances isn't funny to me. And I think we need to not lose sight of the fact that people are suffering.
Any other questions, comments? Ms. Gerard.
Thank you. Senator Armstrong, thank you for letting me speak with you today, and thank you, Chairman Westerfield and members of the committee for allowing me to be here. So a couple of things that were mentioned in the research is representation, right? Who has representation? Who's able to get representation? And not many people. It's not required to have representation in the domestic violence order process or the TIPO-IPO process, which is dating, sexual assault, and stalking. Okay, so I want to make that clear. There is the protective order court, right? But we've got two separate orders. We've got the TIPO-IPO world, and then we've got the DVO-EPO world. DVO-EPO world is a domestic violence familial relationship. TIPO and IPO is a protective order as it comes to dating violence, stalking, and sexual assault, okay? All are serious concerns for safety, and all are extremely dangerous, and they do belong in a court and where protection is had. So I want to make sure that we have this distinguished for that question earlier. Now, representation, Legal Aid, Micah Legal, The Nest, Apple Red only has so many humans. I gave legal advice and representation to 309 people in the year of 2023, and I was physically able to be in court for 98 of those people. I work for The Nest. I am an attorney who represents people in protective order court, and I am very proud of what I do. And in my previous job, I was a felony prosecutor at the Fayette Commonwealth Attorney's Office, and I specialized in prosecuting cases of strangulation, which of course, as we all know, overlap with domestic violence. So I do think it is important that victims of domestic violence and interpersonal violence do have representation in these hearings. Why? Because they are complicated. When people think of domestic violence, they think of a picture of a black eye, here's my evidence, and I'm done. And that is just not the case. In these cases, it is complicated. Children are involved, and custody is involved, and financial support is needed for people to get out of a relationship and gain independence and stay away from domestic violence. And that is the experience I've had from working this job over a period of time. So representation is absolutely needed, and I'm overwhelmed. Legal Aid is overwhelmed. We cannot help everybody as much as we would absolutely adore and love to. So that is an issue that Senator did point out. And there are many times where the aggressor, in my experience, the aggressor is the financial stakeholder in the family and can afford the big-time private attorney to come in, and then the petitioner who is trying to be independent, trying to keep their head above water, cannot afford such an attorney. And they are alone in rural areas in court. In urban areas, there is very much access to resources, but it's still not great, folks. I have struggled to get clients into shelter. I have struggled to get their utility bills paid for them to keep their head above water. And you know what happens when we can't do that for those people? They go back to their relationship because it's a coercive control relationship that they cannot get out of. So it is extremely important that we have what I refer to as wraparound services. Wraparound services is not just legal representation, but it is community advocacy, participating with each other, speaking and talking to each other, and having it a community issue and focusing on the accountability of these aggressors. If we are together as a community and working together to give wraparound services, we can put somebody up in shelter or a hotel or a house with their children to keep them safe, offer financial need to cover utilities if they're staying in the home. We can do things to make this victim independent, make this victim not have to depend on this aggressor that has taken complete control of their lives and their children's lives. So as a representative of victims, I am an attorney, I do go to court, but I am very blessed with having community partners who I work with to make sure we offer those wraparound services. Rural counties don't have that. Rural counties are at a serious lack of that. And a lot of times, the only resources I can offer to my clients in rural counties, because I do cover 17 counties, I don't just cover urban counties, I also cover these rural counties. The only thing I can give them is, well, there's resources over here in the urban county, you can come over here. Well, can they? Do they have a car? Does the aggressor let them drive their car? Do they have enough car seats to put their kids in the car to get to the urban county? Do they have money for gas? Can they afford food, clothes to be able to go to this urban county? 9 times out of 10, no, they can't. So what do? Stay where they're at, because a lot of times domestic violence victims will take a beating a day to keep their kids safe. And that is what we need. We need those wraparound services in these rural counties. We need to be able to help victims of domestic violence and interpersonal violence to be able to gain their independence. So as representation goes, yes, we need a lot more attorneys to represent these people, but we also need the resources to offer to these rural communities to allow them to know how to file a protective order, where to go, what to do. So that's extremely important. On top of that, we also need to recognize that service is an issue. It's very much an issue. We cannot get these people served to be able to get into protective order court, and we need to have access and ability to do that. In some of these rural counties, there's only one deputy who can actually act in service to serve these protective orders. Okay, in a lot of counties, there's only a couple or 3. Well, how are we supposed to depend on one person to do a service for an entire county, even if it is small? What if they're sick? Right? So there are certain things that we need to improve on for service, certain things we need to improve on for wraparound services for these rural counties, and to support our urban counties who are overwhelmed in their dockets and need more resources and more efficiency to be able to efficiently move forward in these cases.
Thank you, Mr. Art. I appreciate that. We do have some members that want to speak. Senator Wheeler, you wanted to respond, and then Senator Storm and Representative Deeds.
I just want to respond to the implication that I was somehow trivializing this. I don't think this is a very funny subject matter at all, and I can promise you my client didn't find it a very funny subject matter at all when he was falsely accused and had to go to court on multiple occasions. And, after it was found out that the person was not being truthful, nothing was done about it. This is a very serious matter. These are very serious cases. There is the need for protective orders, but there's also a need to protect the innocent when these things are falsely used.
Senator Storm.
Thank you, Mr. Chairman. As it relates to your presentation on page 4 of the handout, page 5, you talk about judges entering ancillary orders and low rates of ancillary orders regarding child support and child custody. Are you advocating that in EPO proceedings that judges award child custody and or child support without the due process hearing that would be required in a custody case or a child support case in the family court division?
Thank you for the question. So the statute gives judges discretion in protective orders specifically to enter temporary orders on child custody, parenting time, child support, in part because the statute is designed to give judges the tools they need to stop further acts of violence from occurring. And so there's a lot of the data that says whenever you can get someone who's trying to leave an abusive relationship access to child support, that's one of the things that can de-escalate conflict between the parties. There's an order about finances. There might be an order about how they're sharing time. And it also provides that financial independence for someone who perhaps has been experiencing the type of relationship where they haven't been able to access finances or control their own money. And it gives them the financial independence they might need to leave that relationship. And so I'm not here to advocate for any changes to the statute, and this is one that the law already gives judges that discretion. My interest is in how judges are utilizing that discretion, and is it different in different types of courtrooms? And I think what you see on this slide is that it's not really different in different types of courtrooms, but across the board, we see a majority of judges declining to utilize their statutory given authority to address things like, again, temporary child support, temporary custody, temporary time sharing.
May I have a follow-up? And isn't it true that because those temporary matters are generally set forward in a motion that's been filed and it's a temporary hearing, there's due process afforded that would be separate and apart from an EPO hearing?
I think, sure. So if there is a family court case like a divorce, and I'll speak from my experience because this isn't something that my research necessarily has numbers on yet. If there's a pending divorce case, what I would often see if judges did this is they would say, okay, I'm going to set child support until next month when we have a hearing on child support in our divorce case or our custody case. Until we get to that point, I'm going to put an order in place that says y'all are going to share time with your children in this particular way. It's about giving some structure to parties until they can get into court for more permanent orders. And often there is an opportunity to do that through a separate case. But it's about sort of making sure that there's not a gap where folks don't necessarily know what is going on or how they're supposed to share time with their kids or how they're supposed to support those kids financially.
Last question to Representative Dietz.
Thank you, Mr. Chair. I have a couple of comments and then questions. Senator, we've talked about some of these. And first I'm going to talk about service. And the last discussion we had is the necessity for AOC, when our clerk's office is going to upload through the system the actual motions or petitions for the EPO and then getting them to the sheriff's office or the constable or whoever serves those. And the information I think that we found out is those systems aren't working together. And I've talked to my local sheriff. So I think that we need to explore that probably as a committee and maybe even have AOC and the sheriff's office in here to talk about how can we get those systems to work. So that's first, and I don't know if you were able to look at that after the last time we talked. Second, I just want to address the ancillary orders, as did Senator Storm. I see that as an ex parte. When you're getting an EPO, it's ex parte. You're filling out the affidavit. It goes to the judge makes a decision. It's temporary until there's a hearing. So I think I'm less concerned about that due process because it's ex parte, but I just pulled up the AOC form. And the AOC form actually requests, like for child support, they have to bring the same things to court that we do in a temporary child support hearing. They have to bring their pay stub, they have to bring their tax returns, the same things that we have to bring to a hearing. There's also boxes on here that you can request the family pet, which, we passed legislation this last time with domestic violence. So I agree with you that if some of our judges were able to enter some ancillary orders, that it could reduce the actual physical act. But looking at the form, it feels like the form's there. My question and concern is I don't know that our courts have time to turn that into then a hearing on child support and custody. So I see it more as a ex parte, and maybe by the time in 2 weeks they get to the hearing, then that order changes. But I look at it more, I know our courts don't have time. If you've got 50 cases on the EPO docket, there's no way they've got that time during the day to have a hearing on custody.
Yes, thank you. And Representative Dietz, I just want to thank you for being such a champion on this issue and really leading when it comes to legislative ideas to support survivors of domestic violence. And I'm very grateful for all of our conversations about it. And just to clarify, I don't know that I've ever seen a judge enter it like before a hearing has happened with the parties. I've seen judges enter child support. I guess I'm talking about once we have a respondent, a petitioner in court, judges, and that's what this number reflects, judges have the ability as part of that hearing of, am I going to enter a DVO and find that domestic violence has occurred? They can go ahead and address child support and child custody as part of that, even if there is another pending matter. And so I think perhaps I misunderstood Senator Storm's question. Apology, Senator. I am not advocating or speaking about the time period prior to a hearing taking place because I agree that would be tricky from a due process standard before there has actually been someone served and before they've actually come to court. And so these numbers only reflect as part of the DVO hearing, not the EPO process. So I think I was unclear on that. And Representative, I think you're right. We ask a lot from our judges, particularly our family court judges. We know that they are overworked and they have too much to do and too few resources to do it. And so I am certainly in no way trying to suggest that they don't do enough or criticize the work that they do. My concern is how do we get them more resources?
Very quickly, yes, ma'am.
And I forgot to ask this. It was about legal aid when we're talking about resources. I know an issue for us in Northern Kentucky is that they run it like a law firm, right? So there's conflicts checks. Most of the time, legal aid can't then take the clients that are coming in because they've already represented someone in the family. So I don't know if that's someplace that we can look within these different organizations on how we reduce that, but that was my immediate thought when you said that, the legal aid can't help is there's so many conflicts for them.
Yes. In Fayette County, I'm in 17 counties. Fayette County is one of my county. We have multiple legal aid, in essence, nonprofits, right? We have Michael Legal. We have the Nest, which is me. I'm the only attorney at the Nest. It's just me. So we have Michael Legal, we have Nest, and we have legal aid. But often people will call me after trying to call legal aid because they got conflict out. I used to be a prosecutor, so I also have to conflict out of some people who call, right? So conflict is definitely and absolutely an issue with getting people representation who had to have been turned down. I have had to turn many down for capacity issues as well as conflict, and gave them the resources. And often they'll tell me, Aubrey, I already called all those people, and I have to say I'm so sorry. There's nothing I can do, and they're in court by themselves.
Thank you both. I know Senator Berg has a question, so I'm going to let you all connect with Senator Berg after the meeting because we need to move along. Thank you both, Senator. I appreciate it. Mr. Gerard, thank you. Keep the hammer down. It's important work, so I appreciate it.
Thank you.
All right, our last presentation and update, our annual update on Senate Bill 90, the pilot program. I want to welcome up Jason McGinnis, Interim Director of AOC, Angie Darcy, and Jason Dufek. Come on up. I'm eager to hear the report. You have the floor.
Good morning. Good morning.
There you go.
Thank you so much for this opportunity to speak to you about Senate Bill 90 and about the Behavioral Health Conditional Dismissal Program. My name is Jason McGinnis. I'm the interim director for a very short period of time. Then I'll be back to the deputy director position, which is a good thing. I'd like to introduce Angela Darcy, who's our executive officer of pretrial, and then Jason Dufek, who is the manager of pretrial.
Before you jump in, is Mr. Ramsey here?
He is not. Unfortunately,
Okay.
He's still working his other job.
Okay.
So yeah, he couldn't make it. He is watching. So I think so.
Very good.
So we're honored to be here, and we thank you, and we're really honored because it's your last meeting, Senator Westerfield, so this is a special occasion for us as well. We want to thank everybody for the opportunity to talk about the Behavioral Health Conditional Dismissal Program, and it truly has been a privilege to be a partner in implementation along with BHDID, and then we also have our partners with Kentucky Adult Education and Workforce Development here today as well. So I could start this presentation off with a bunch of facts and a slew of data on Senate Bill 90, but today I chose to start with a story in honor of Judge Kevin Mullins. So he was our pioneer and our champion of Senate Bill 90, and he had the unique ability to personalize Senate Bill 90 with stories of the individual that took part in the program. And in collaboration with Mountain Comp, they created a video that we're about to show you, and it is Patrick. Patrick is one of our participants and our graduates of Senate Bill 90, so we are proud to show this video and in memory of Judge Mullins. I had to hit a button.
In early life, I grew up, my dad was a coal miner. My dad, 42-year coal miner. So initially I wanted to be like my dad. I found out that my child's biological mother was pregnant. I knew I had to make ends meet. So I done what I had to provide for my son. Life happened. Life got in the way, so I had to go to work. After my injury in the mines, stuff laid up, got behind on bills. I got behind on my child support, and it led to me having flagrant non-support felony charge. Senate Bill 90 was described to me as a program that, as long as I stayed compliant, that within 5 years or within the time I paid my back child support off, that my record would be clean. Mountain Comprehensive Care Center helped me with behavior health. I've never had a problem with addiction. I have anxiety and depression. They helped me get my anxiety and depression in check and just better my life, make the quality of everyday life a whole lot better. It helped me get on the right path. It helped me get what I needed to get into the career I'm going into. It helped my family. It helped me with the tools that I need, that it won't be such a burden on my family if I have to go buy straight up. So the money I make can go straight to help and benefit my family. Regaining custody of my son, seeing him with my wife and him happy in the environment that he is happy in has pushed me so far. It's made me want to do better, be a better man for not only my son, but for my wife as well. I want them to be able to have anything and everything, a better life than I've ever had. Because of the opportunities from Senate Bill 90, I've been able to change my entire path in life. My life is no longer looking down, it's looking up. Now the sky's the limit. Just believe in yourself, put your head down and grind. Do what it takes. I promise, I was in the bottoms, now I'm on top. I never thought that I would be an instructor, that I would be going to work in line school. I never thought a year ago that I'd have custody of my son, that I'd have graduated top of my class. But if I can do it, you can do it.
We're really proud of Patrick and all the work that he's put in and how he's taken these opportunities that Senate Bill 90 gave to him and really just ran with it. He's worked so hard, and it seems like a long time, but he's just pushed through it, and we're so proud of where he's at now.
I'm proud of my dad.
Senate Bill 90, Hazard Community and Technical College here in Hazard, Kentucky, and Mountain Comprehensive Care Center has changed my life, and I'm climbing new heights.
That tells you a little bit about Senate Bill 90, and it's an inspiring video, and Judge Mullins was definitely a champion of the program, and we desperately miss him. So just a brief overview. It provides an alternative to incarceration. It allows eligible defendants to receive treatment for behavioral health disorders, which include substance use disorders and mental health disorders. It diverts eligible defendants away from the court system and into substance use disorder treatment and also mental health treatment. And it also gives them an opportunity to better their lives. So it has a wide array of services, such as adult education. They can go to college, they can go to cosmetology school. If they choose to, they can just get a GED. Some people just want to read. So it's just really an opportunity to try and improve lives and then get some people that treatment that they so desperately need. When I describe the program to our partners when we're getting ready to go into a new area, what I tell them is, with our criminal justice partners, think about the case like it never existed. We're going to get them some help. And then when we get them some help and we're successful, then we're going to come back on the docket and we're going to have a little celebration and we're going to dismiss the charges. Some people who are not successful or drop out of the program, they'll be back too. But we're diverting them around the criminal justice system versus putting them in the criminal justice system, in the court system. Many of our participants just have one court appearance, and then we're going to get them right into treatment and get them some help and change their lives right away. So here's the eligibility criteria. So it is for low-level offenders. It is not for somebody that would be high-risk, high needs. It is somebody that would be, it's probably their first criminal charge that they've ever had. There are certain disqualifiers, for example, DUIs, previous DUI offenses, assault force, previous assault force offenses. So there are certain disqualifiers there, but the prosecutors have the opportunity to override some of those disqualifying offenses and put them into the program themselves. And we've seen a substantial amount of prosecutor overrides in this program. So we had our very first 2023 annual report. It was definitely a challenge, but we got it done. We're proud of it. And we believe that it was a successful implementation. It was kind of a slow start because it was a lot to figure out in the beginning. And so, but the annual report takes you on a journey, of statistics, testimonials, and a lot of data. It's very data rich. So here are Senate Bill, skip to the next slide if you would. So here are our go live dates with our Senate Bill 90 counties that were originally in the pilot. We have Letcher, who was our very first one. So that was our very first pilot. And then we finished up with Kenton on 5/1 of 2024. Once all 11 pilot counties were live, we had a discussion with all of our partners to discuss expansion, because what we realized is that our case navigators could take on a little bit more work, and so we are substantially expanding this year, and next year we have even more plans to expand this program.
Angie, do you already have counties that are expressing interest?
Yep, we do.
Excellent. Thank you.
So we have, we are now live in these counties as well, so with the exception of Pike. So we have Henry, Lewis, Wayne, Warren, Johnson, Russell that we're live in, and those are neighboring counties of all our Senate Bill 90 counties. And we are looking at getting started in Pike in the next couple months.
What the status of those? Have you had the community meeting talking to prosecutor, judge, all the players that are providers there?
So what we've learned with Senate Bill 90 is, and you'll hear it in the end.
Or you might be saying, are you not going to have those meetings, or are you doing
No,
them differently?
We're doing them differently now.
Okay.
What we're doing first is talking to our judicial and our criminal justice partners, because we realize that that's where we have to start with and get the interest from them. Because if we don't have the interest from them,
sure,
we're not successful. So we're starting there, and then once we get an agreement of all the parties and a meeting of the minds, then we do our community meetings.
Good afternoon, everyone. If I could speak briefly on the data. So Senate Bill 90, as you know, requires treatment providers, requires prosecutors, county attorneys, Commonwealth attorneys to collect a large amount of data and on all the folks that are participating in the program and some of the folks that are even denied entry into the program. That data is collected by way of 14-day reports, 42-day reports, quarterly reports.
You might move the mic over a little bit.
Yes, sir.
There we go.
So all of that data that we capture is being done by reports coming through a system called DDoR that the healthcare providers use. It's the 14-day report, the 42-day report, the quarterly report, and final reports. Some just quick examples of the data collected: number of eligible participants, number of clinical assessments that had been performed, the number of folks that are discharged for noncompliance, number of people who successfully completed, number of victims that agreed or disagreed with the person's participation in the program. So if you look at the bill, there's an array of data, and we're capturing all of that through a couple different means. To speak about the eligibility, the folks, as we're screening them, as Angie pointed to, low individuals are automatically assessed further or screened for entry into the program. So of the folks that we've interviewed, 1,400 have been eligible for the program that were low, and about 4,600 were ineligible for the program. The rest of these numbers just indicate those folks that are moderate or high FTA, high NCA rates.
Do you have any sense of on the bar there that's the biggest, the any moderate, or maybe you have this in another slide? I haven't looked at your slide deck yet. Are there is there anything you can tell us about that population of offenders?
Well, I have a slide later that may answer some of those questions,
Okay.
but if it doesn't, we can certainly discuss that.
One of the things that I would hope that the legislature will do in the years ahead is expand the eligibility. There's obviously a ceiling. There's a point at which people aren't going to be comfortable with offenders participating in that and getting the benefit of the program, and I get that, and I would agree. There's a ceiling for me too. But we're talking about getting people who the prosecutor and the defense and the court, everybody agrees needs behavioral health intervention, and we're leaving a lot out that could benefit from behavioral health intervention.
Yes, sir. And I can touch on there's a slide that I'll show you just a little bit. We can dig deeper
12
into
years
that.
I haven't learned to just keep my mouth shut. Go ahead.
So I've also included in the slide deck, I won't necessarily talk to it, but you can see this same graph from last year when we were here speaking. And you'll see some of the numbers have decreased, like our unknowns last year. I think that you kind of poked us a little on having so many unknowns. And some of that was due to the risk assessment being performed prior to the defendant being interviewed. And some of that was just bad data. So what we've done now is we've instituted some quality assurance processes in there where we'll go back and keep an eye on that and find out if those folks ended up being eligible. And if they were, we were reaching out to them. So we've tried to eliminate some of those, not entirely done so. We had 18. So here's the eligibility factors. So this is kind of what we were talking about, and I'm sorry that I cut you off before, but the first handful of questions here, the first 6 questions or so, that is dealing with the current offense. So, what has brought that person into contact with us at that moment. And you can see 85% of the people are eligible based upon being a Kentucky resident. So 14.5% roughly are excluded because they're not a Kentucky resident. The bill requires the person to be a Kentucky resident. Another basically 85% of folks are eligible because they are not charged with an A, B, or C felony. So 15% of the people, A, B, or C felonies, what their current charge is, they're excluded. 4.1% are being excluded due to the current charge being violent. And DUI is the big one, and this is the current charge. So a little bit more than a third of the folks are currently charged with the DUI.
Colleagues, if y'all can find a way that's palatable, that gets drunk drivers access to behavioral health interventions earlier through this program, please consider it. Find a way. I'm not saying they've all got to get a chance. And I don't know what it needs to look like, but that's a category of people who have a behavioral health problem that everyone agrees they need help with. Let's get them help much earlier in the pipeline. I implore you to try to consider ways to do that.
Yeah, and just to put some numbers behind that percentage there, that's about 2,900 people that came through the door that they were charged with the DUI, and that's what kicked them out of eligibility. 15% of the folks were excluded because their current charge was domestic violence or interpersonal violence. 1.7% sexual offense, and 0.3% was the attempted sexual offense. So the next bit of questions on the bottom here, bottom half, that is dealing with the person's criminal history. So what is it that they've done prior to that is cause them to not be eligible for the program? You can see less than 1% have a prior conviction for an A, B, or C felony. 0.1% have a conviction, have a conviction for a violent offense. And again, DUI, get the biggest one here, similar to the the current charge was. 17.4% of people are being, that's roughly 1,600 people that had a prior DUI on their record, and so they're no longer eligible for the program.
I'm going to stop you.
Yes,
Representative
sir.
Decker's got a question.
Yes, ma'am.
Thank you, Mr. Chairman, for your testimony today. We had a committee meeting in the BR on Judiciary the other day. We heard testimony about Rob Sanders, Commonwealth Attorney's initiative with the Life Learning Center, and it sounded similar. Is it the same? I can't remember if it was under SB 8. I don't remember how it started, but is it a similar concept with just a different program?
Yes, ma'am, and I'm familiar with Commonwealth Attorney Rob Sanders' program and the program that they operate in the circuit court there in Kenton County and the district court. It is similar. There's some difference. I think that they deal with higher risk, higher needs individuals, or tend to deal with them more than Senate Bill 90, the Behavioral Health Conditional Dismissal Program, targets those low folks. But yes, ma'am, it's very similar, and we've had many conversations with Commonwealth Attorney Sanders and with Alicia Edgington, who runs the Life Learning Center there.
Well, bravo. I love the program. Thank you for doing it. Keep up the good work.
Yes, ma'am. So again, the largest number of folks that we saw whose criminal background, whose criminal history excluded them, was those DUI offenses. It's roughly 1,600 people behind that 17.4% number. Less than 4% had been convicted of a domestic violence or an interpersonal violence offense. And then the conviction for a sex offense, an attempted sexual offense, or a federal or military sexual, they're none. Nobody's really been excluded because of that. And like I said, in the slide deck, I've included what the numbers were in 2023, but I won't. We spoke about them last year, but they're just there for reference. So of those receiving the eligibility assessment in 2024, then I know it's kind of busy. There's a lot of data here, but one of the takeaways from it is that actually more men are eligible for the program. It's about a 60-40 split is what we're seeing between men and women eligible for the program. But we have the exact opposite percentages of folks that are accepting the program. So we have, while 60% of the eligible participants are men, 60% of the participants are actually winding up being women. So we've begun to look at that from different angles to try to determine what may lead a person to decline entry into the program. We've instituted a survey that once somebody's declined, we attempt to reach out to them. We attempt to talk to them and find out what was it about the program that you didn't think it was an option for you. And our 2024 clinical assessment completion. So this slide kind of speaks to folks that the case navigators have been able to make contact with, and I don't know that we touched on it this presentation, but so there are folks that will actually reach out to people. A lot of times somebody will be arrested and they'll be released from jail prior to us being able to talk to them about the program. So these folks will show up in court and they'll try to talk to the person in court. They'll try to reach them in advance of court if they can to explain the program to them. So once the case navigator is able to make contact with somebody, 95% of the time that we actually speak with them, we're able to get them to complete an assessment. And, that's been huge to us, is just making contact with that person, being able to speak with them, to explain the program to them. Now, it doesn't mean that they're going to have a substance use or a mental health issue that would allow them entry into the program, but we're getting them assessed. And the results of those. So we have 314 folks that that were assessed that came back that they had a co-occurring issues. We had 292 that had mental health only, 36 with substance use only, and then 39 people who there was no indication of either. One thing to note here that we have seen an increase in the numbers which of the no indication, and I kind of credit that to prosecutors taking a chance and referring somebody for an assessment that was not otherwise eligible. While they are coming back that there was no indication, they're giving them a shot and affording them the opportunity for potential entry. So our current statistics, and this is current as of the middle of last month, I have this morning's numbers that are slightly updated. But you can see we have 457 active agreements. Agreements is not necessarily synonymous with people. There may be people that have more than one case, but 457 active agreements. Our largest, Letcher County, was the largest for a long time. McCracken County sits with 148 active agreements right now. McCracken County came on later, but they've really adopted the program quickly there.
This is the opportunity to speak about recidivism. So we've been tracking via the bill our recidivism rates, and we did put that in the annual report, but we've kind of instituted a quasi, like a shorter report that we send out monthly that talks about recidivism as well. And since August, we've been doing that mini report. I think Senator Westerfield, you've received a couple of those reports. And so this goes over all the participants of the program, and also the people that declined entry, and also the ones where the prosecutor declined entry for the participants. So right now we have 125 people that have completed the behavioral health conditional dismissal program. 84% of those have received no new charges. We have 21 individuals that were charged with new offenses. Now, this is just different than the bill actually requires us to track those that have been convicted or have been charged and convicted, but we're just keeping our eye on the pulse just to see who has been charged, because we thought that would be an interesting point to capture. So we have 9 that were charged with traffic-related offenses, 6 misdemeanors, and 6 felony charges. And then when we go over to the declined defendants who didn't want to participate, we have 478 that declined to participate. And for recidivism rate, we have 67.4% that haven't received new charges. And then for the prosecutor declined entry, we have 236 declined entry into the BHCDP by prosecutors, and 75% of those have received no new charges.
Couple of quick questions. One, are you all, for both Jason Dufek's data chunk of this presentation and this, are you tracking or breaking it down by race?
Yes, sir.
Does your annual report show that data?
I think it does.
It does.
Okay. If not, I'd ask you to add that to make sure. I assumed you were tracking it, but I think it'd be important for the members to see it. And then the bill required that prosecutors that declined provide a reason for declining. And my fear in putting that in there, I wanted to put it in there. It was my bill. I was happy to put it in there, but I suspected we'd get some boilerplate, same sentence or two that they'd slap on everything. Is that been generally what we're getting, or are you getting prosecutors that are intentionally laying out specific issues they have with that particular?
I think we have both. So I think we do have some boilerplate language. There might be another diversion program that they want to put the participant in, and then we have some where they'll actually give us spell it out for us.
And did anybody ask why the defendants declined? Do you know? Did have counsel for defense given any sort of answer on why?
So we are conducting a survey to find out why the defendants decline. So we're actually asking them when they decline, and most people do have counsel when they enter the program. So
That's a pretty high number. I'm surprised, particularly with the benefit. I mean, they've got it. It's hard work, but they get a dismissal at the end of the road if they obey. All right. Thank you.
So now we're going to talk about the additional benefits for the participants. We have one of our partners back there with adult education, and we're going to highlight some of the things that they've been doing as well. And we would also like to give a brief shout out to Medicaid and Medicare, Department of Medicaid for they figured out the reimbursement rates for the housing, and that was a difficult task for them. So we now have those recovery centers up and running as far as taking in Senate Bill 90 participants. So that's been pretty critical.
Before you leave, Representative Decker, is she still here?
Yes, I'm sorry. Thank you.
Yes, ma'am.
So there was something blocking my view, but just a second ago I saw AOC Special Courts Administrator Elizabeth Nichols from Shelby County wanted to welcome her. Sorry I missed that at the first, but I also want to recognize her decades-long service
Yes, ma'am.
to the Commonwealth. Thank you.
Thank you, Representative. I promise she asked for that a long time ago, but I was waiting for a spot to get her to do that. I didn't want her to leave without having a chance. So thank you for your patience. Sorry to interrupt. Go ahead.
No, you're fine.
And we've got about 9 minutes.
Okay.
We don't have about. We have exactly 9 minutes
Okay.
before natural resources starts.
So then I will whip through it. So we have the barrier relief support services. This is our recovery capital. This is everything from if they need temporary groceries, we'll buy them some groceries. If they need a tire, on their car, we'll provide that. If they need dental work, that's something that the Barrier Relief Fund would provide for. So far, the total spend to date is $62,215 for that.
So is that out of the $20 million?
Yes.
Only $60,000.
It just started. We just got it active in May because of contracts that we had to put in place. So it's relatively new.
Okay.
We're ramping it up. So in September, we had 72 total referrals. In May, we started with 4, if that tells you anything. And so we've had, so far, 116 participants served with barrier relief. And then these are just some of our Kentucky Adult Education in Action stories. We have 2 participants that are attending Hopkins Community College, and one has graduated and gotten a CDL. You can see his picture there standing by the Pepsi truck, and this is just for your reading. So Kentucky Adult Education also has a separate fund for barrier relief to provide for educational resources. So that's separate and apart from the emergency barrier relief services. So adult education, that also went up in May, is that correct? So that also went live in May as well. And so far, that trust has been used to service 14 participants. They have paid $11,909 to date, and they have pending payments in the total of $25,373. So that's for things like education, like cosmetology school, right? Going to college. So they are ramping that up as well, and we have a new team with the Kentucky Adult Education and Workers' Comp, Aaron Pointer and Michael Updegraff in the back, and they've been amazing so far. So we're really appreciative of that partnership with them. And so here's some success stories from the field. As Jason has gone over, I'll just let you read them. They are from our case navigators who are able to observe those. And our next thing is, so now we're planning for the future and what that looks like. And we're doing strategic planning with our partners for our behavioral health conditional dismissal program to talk about things like sustainability and growth. And what are our measurable goals for the next few years while the pilot is in place. That's also been with Adult Education, BHDID, and Executive Director Ingram. So here are our accomplishments. I have a note on here that says that I need to read this enthusiastically. So we do have continued collaboration, and I think that's one of the major things that we've really realized from Senate Bill 90 is that collaboration has been really key. And we've met all sorts of partnerships, and we're starting to incorporate some of those things even in our regular pretrial world. Like we now have a great partnership with Kentucky Adult Education, and we're starting to incorporate some of those things with pretrial services. So that's pretty neat. We also have the data platform launch of DDoR. We have the emergency barrier relief funds for both adult education and also for just the barrier relief. And we have so many success stories. What you've seen today is just a drop in the bucket. But it is a hard program to complete. It's not easy for them. But it changes their lives, and when you hear the stories, you're so moved, and you can't help but just be, your heart is warmed by just the sheer velocity of the people that we're helping. And so it really is incredible. And we also have our strategic planning underway. And last, I'll lead it with barriers. So we do have several barriers. There are some counties that we've kind of stalled with participation, and we're getting ready to have meetings with them to see what we can do there. And there's just that overall continued hesitation from some of those partners. It could be, the prosecutor, defense attorneys, or sometimes our other partners. And there's also the role clarification. We're learning that for our partners and providers. Like, what do the providers do? What services should they provide? What does Kentucky Adult Education provide, and BHDID? So those are kind of some of the barriers. We are working through them, and we are more intentionally now, I think, with our expansion, entertaining, because we want to make good use of this money. So we want to actually be more intentional about where we're going in the next places, because we want really good participation. And so we've learned some lessons. And that's it.
Any other questions? I've asked all mine. Seeing none. Can you all give us a copy of the report or send it to us?
Absolutely.
The 2024 report?
Yes, sir.
I'd appreciate that. We'll get that to members, and if it's all right, put it on the website for this committee meeting. Chairman Elliott.
Mr. Chairman, before we adjourn, I want to tell you how much I've enjoyed serving with you here. I've felt like I've been in the catbird seat here the last couple of years because of your service. And I know you've been on this committee since you came into the Senate. So started out as chairman, so I wasn't able to do that. But I want to thank you for your service, and I wish you and Amanda and your family well. And I want to thank you for your friendship, and I know the people in Christian County have been very proud of your service, and I know you'll continue serving in other ways. But before we adjourn this, I just want to tell you how much you've meant to me, and I wish you well.
I appreciate it. Thanks so much.
Great job, guys. Great.